I'm Michael Devlin. I'm Head of Professional Standards and Liaison here at the MDU. Been with the MDU for an awful long time, since 1997. And I'm joined by two of my very experienced and highly expert colleagues, Dr. Clare Sweeney and Dr. Ed Farnan. Now, starting with Clare. Clare graduated from Queen's University in Belfast in 1990. She trained as a GP, and before joining the MDU way back in 2015, she was a GP partner for over 20 years. She's got a master's degree in law and has also done an advanced diploma in medical law from King's in Dublin in 2023. Clare also has a special interest in the legal and ethical aspects of end-of-life care. And secondly, I'm delighted to introduce also Dr. Ed Farnan, and he's been with us now at the MDU for over 10 years. Like Clare, Ed was also a GP, in fact, like myself too, was also a GP in Armagh, and where he was also clinical governance lead. He's also got a master's degree in medical law, and sat on a regional research ethics committee during his time as a busy practicing clinician. As well as his role as an MLA at the MDU, he's part of the medical education team here at the MDU. I'm just, before I hand over to Ed, who's going to take us through the slides, and then we've got a panel discussion to take your questions of myself, Clare and Ed. Just put up this slide for you to have a quick look at, telling you a little bit about the membership that the MDU offers hospital doctors in Ireland. This, as you can probably garner, is something that's particularly relevant to those who are, perhaps new consultants or are in a training grade about to qualify as a consultant going on to the new Sláinte Care contract. So the key points are listed there, and indeed if you do have any questions, then please do get in touch with us and we'll follow up with you. But without further ado, and again, my apologies for the gremlins at the outset, I'm really happy now to hand over to Ed Farnan.
Thank you, Mike, and thanks to those of us who have persevered for joining us. I hope that this will be a useful session. It probably won't last too long.
Can I just butt in and say the questions are to be typed in the question box, if you wouldn't mind, and if you get those in early and keep them as short and to the point as possible, then we try to get to as many as we can at the end of the talk. Sorry for butting in.
No, that's a good point. The question box is where to put the questions, and the quicker you get them in, the better, because it means we're not chasing around at the very end trying to answer all your questions. We will pick them up as we go along and have a discussion at the end. But we start at the very beginning to channel Julie Andrews from The Sound of Music. It's a very good place to start, and the start in terms of the ethical basis for what we're talking about today goes right back over 2,500 years to Hippocrates. So, much of the ethical principles in medical practice go back that far, and indeed even further. And one of the ethical principles which he described in the Hippocratic Oath, if you were to Google that, you'll probably get various different translations, but one of them says this, that whatsoever I shall see or hear in the course of my profession, as well as outside my profession and in my intercourse with men, if it be what should not be published abroad, I will never divulge, holding such things to be holy secrets. So, that's the sort of the historical basis for the principle of ethical confidentiality in medicine. Moving on, slightly more recently, in 1948, the World Medical Association adopted the Declaration of Geneva, and that's been amended and revised several times since, most recently in 2017. And this was essentially a revision of the Hippocratic Oath to try and make it fit for purpose in the modern world. It's what I think many medical students will sign or declare at the end of their training rather than the Hippocratic Oath nowadays. But confidentiality continues to be an important part of that. So we talk about the ethical principles, which is what the Declaration of Geneva is. It's what the Hippocratic Oath says. It's also what the Medical Council's guidance is. The Medical Council produces a publication which is essentially a handbook for medical practice. We'll look at a bit more of that later, handbook for medical practice from the ethical perspective for doctors. But in addition to that ethical obligation, we also have the various legal obligations in terms of confidentiality. And we're all likely to be familiar with some of the provisions of the Data Protection Act, which mean that you have certain legal obligations relating to the data that you hold about your patients. And the Medical Council says in relation to this that you're required to comply with data protection and other legislation relating to the storage, disposal and access to records. And it also says that you should understand the 8 rules of data protection, which are specified within the Act and the General Data Protection Regulation. Article 8 of the European Convention on Human Rights guarantees a right to respect for family and private life. Although it's not an absolute right, there are exceptions and there are balances with some of the other European Convention article rights. The Constitution of Ireland, Article 40, doesn't specifically include a right to medical confidentiality, but it does say that there's a qualified right to privacy, and rather like the European rights, it's not absolute, it's qualified. There's not a huge amount of case law on confidentiality in Ireland. There is more in other jurisdictions. I suspect that because of the constitutional rights, because of the European Convention rights and other rights, it's never really been that necessary to test it through the courts, but we will look at one case later on which might be of interest. And in addition to these ethical and legal rights, you should also make sure that you comply with any local policies which might relate to confidentiality and any contractual obligations which you might have. I mentioned the Medical Council's guidance, and as I say, there is a publication, the Guide to Professional Conduct and Ethics, which is available on the Medical Council's website. If you haven't read it, I would suggest that it's worth certainly having a flick through. It covers all aspects of medical regulation in terms of what the regulator expects of its registrants in terms of confidentiality, consent, and various other issues. It's important to know what your regulator says because those are the standards that you will be held to. And it again recognises that confidentiality is central to the trust between a doctor and their patient. It's a core element of that relationship. But it also recognises that sharing information in some circumstances may well be appropriate either for the patient's benefit or for the safety or benefit of others. In addition to the guidance here, the Medical Council says that you should protect your patient's privacy by keeping records and other information about patients securely, and you should guard against accidental disclosures. So we've seen that the information that you hold about your patients is confidential. We've also seen that confidentiality is not absolute. There will be circumstances where you can share information which would otherwise be confidential. And it may help to try to think about situations where you might breach patient confidentiality under a number of discrete headings. And what we'll do now is look at each of these individually with some examples, but in terms of the headings that I'm mentioning here, that broadly speaking, it's these 3: sharing information with consent, sharing information if you're required to do so by law, or sharing information where there's a public interest in doing so. The most common reason for sharing patient information is for the purposes of direct patient care. So that might be writing to a GP or referring on to a colleague. And while you might wish to rely on the possibility that consent to do so is implied by the patient, the Medical Council would expect you to explain to the patient that information is being shared for their benefit and with whom that information is being shared. You might not say in huge detail what you're going to share when you're referring to another colleague, but you will say in broad terms what you're planning to do. If a patient doesn't want you to share information that you believe as the referring doctor is relevant, then you should discuss with the patient the possible consequences of this and see if you can reach a compromise. If they can't be persuaded, then you shouldn't share that information, but then you may need to explain to the patient that you may be limited and possibly can't refer them or arrange treatment without providing the information that you believe is necessary and relevant. If you have consent, you can share information for other reasons, such as with a patient's solicitor or an insurance company, but you'll usually want to see explicit written consent in that context. As an example, a patient might be making a claim following a road traffic accident, and their solicitor will want to see their records. The patient may understand in that situation that the solicitor will ask for records directly relevant to the injury sustained in the accident, but the patient might not understand that the solicitor will probably also ask for their entire record, which they might need to ensure that there was no other medical problem which could make the claim more difficult to bring. So if you're in doubt about what you're being asked to disclose, it's worth checking that the patient understands what is going to be disclosed and ensure that their consent is fully informed. Just have a quick look at a case scenario. You can imagine perhaps you're a patient, a psychiatrist looking after inpatients. One of your inpatients develops diabetes, and you wish to refer them to an endocrinologist to get some advice about the management. So the question really is, what are you going to tell the patient? And what information will you share? It's generally not going to be particularly contentious here. The patient, if they're told that they have diabetes and that it would be to their benefit to be under the care of an endocrinologist, is probably going to be happy with that. They're also probably going to be reasonably happy that you share relevant information about their health, why they're currently an inpatient, what medication they're on, when they developed diabetes, what other medical problems they have. That's unlikely to be particularly contentious, but it's worth thinking about in general terms what questions you should be asking yourself before you make the onward referral. Contrast this situation with the situation where you've got a patient who's HIV positive and who needs to have a surgical procedure, but they don't want the information about HIV to be shared with the surgeon. The question then arises, is it directly relevant for the care that the surgeon is going to be providing? Perhaps they're on medication, which means that their chances of transmitting that infection are incredibly low. The surgeon, of course, will be taking his own history from the patient, and also when it comes to the surgery, will be protected by the usual methods, gloving, sterile field, and so on. So that's sort of a debate which you might want to have with the patient, but bearing in mind that there are other means by which a surgeon can protect themselves against infection. Second scenario, you're an ED consultant. You see a patient in the emergency department who's been assaulted. Sometime after this, the Gardaí come to you and ask you for a statement. Well, what questions are you going to ask here? Well, again, do you ask for evidence of consent? Do you approach the patient, or do you ask the police to do so and show that they've done that? Can you provide a statement without explicit consent? Well, I think the context is likely to be relevant here. Where is the patient? Were they well discharged home, no long-term sequelae, and therefore in a position to give consent if they were approached? Or are they in intensive care following a serious head injury, unlikely to recover, certainly within the foreseeable future, which might have an impact on the police investigation and how quickly they can proceed? Can the Gardaí give you sufficient grounds for you to proceed and justify sharing information without consent? Well, perhaps not. In most cases, probably not. You will want to see consent in most cases in this scenario. But we'll look at a slightly different scenario, the twist on this, a little bit later. I mentioned consent. I also mentioned that you might be required to disclose information by law. And there are a number of laws that do require you to disclose relevant information. Things like infectious diseases legislation. If you see a patient with a notifiable infectious disease, then you're required to raise that through the usual channels. The most common of those recently, presumably, will have been COVID-19, which is notifiable. But there's a very long list, and it's probably worth checking that long list to make sure that you're aware of what they are if you're in a specialty or discipline where you might come across this. Others are things like measles, chickenpox perhaps. Smallpox is still notifiable, even though I suspect most of us haven't seen a case. But we'd want to notify it if we did. Other things where you might be required to notify or disclose information would be certain deaths which need to be notified to the coroner, for example, or registration of deaths. In such cases, whether you're notifying an infectious disease or similar, you should ensure that the disclosure is actually required before you make it, and disclose only which information is absolutely necessary and relevant. In most cases, you should tell the patient that you're making the disclosure because you're required to do so by law. You have to also share information if you're ordered to do so by a court or another body that has authorities to allow this to happen. If you receive any correspondence suggesting that you are being ordered to share confidential medical information, and if you're not sure about it, then you can certainly seek advice from the MDU. It would be usual in such cases to tell the patient that you're going to share information, but there are some cases where this would actually undermine the purpose of the disclosure. If you're in doubt, again, the person who's requesting the information should be able to clarify whether they think that's the case. The final category really is the more challenging one, perhaps, in terms of day-to-day practice. It's where there's a disclosure in the public interest. Now, there is a public interest in there being a confidential medical service. Patients are more likely to attend, to seek help, and to disclose sensitive information to their doctors in that context if they know that information will remain confidential. There may, however, be circumstances when the patient's own individual private interest in their information remaining confidential, and the wider public interest in there being a confidential medical service is outweighed by the public interest in that information being shared. If the patient doesn't agree to the information being shared, then you as the clinician will have to balance up the potential conflicting interests before deciding whether or not to share information which is relevant in the wider public interest. Probably the most common thing that we get in terms of queries from our members at the MDU in this setting is whether to disclose information about drivers to the licensing authorities. The relevant guidance is Sláinte agus Timonch, which is Health and Driving, which is published by the National Driver Licensing Service, and it's issued jointly with the Road Safety Agency and the National Office for Traffic Medicine. And these guidelines outline what busy doctors need to know when they're assessing fitness to drive. The primary responsibility in terms of notifications to the agencies rests with the driver. It's the driver's job to say they've got a health problem and to tell the licensing authorities this. Your role as a clinician is to advise the patient about the impact of their medical condition on their ability to drive, and to advise them of their responsibility to report their condition to the NDLS if their health may affect their ability to drive. So it's important that clinicians are familiar with this guidance so that they can recognise when a patient who's seeing them has developed a condition which requires notification. There's the health professional responsibilities, so it's to assess the person's medical fitness to drive based on the current guidance. This tends to be updated annually. The most recent version was published last year. So it's important that you're familiar with the relevant medical conditions. You should then advise the patient of the impact of their medical condition, advise them of their responsibility to report their condition to the NDLS, and then to treat and monitor their clinical condition in the usual way. You do also have an obligation to report a case to the NDLS regarding a patient's fitness to drive in the exceptional circumstances where there's a risk to the public and the driver can't or won't cease driving, or can't and won't inform the NDLS themselves. So the classic example of that is this, where you are a consultant neurologist, you have a patient with epilepsy who's attending your clinic, first time, or perhaps not the first time, you've seen them before. You've previously told them about their obligations in terms of their notification to the NDLS, but you've reason to believe that they haven't done that. So the question is, who do you tell and what steps do you take? Well, usually what would happen in that case is that you reinforce your advice in the first instance. I certainly would suggest that you follow that up perhaps in writing with the patient, and certainly make a very careful record of what advice they've been given. If they continue to drive without notifying the NDLS, well, in that case, you may well have an obligation to inform the authorities. This is somebody who may well have a condition which makes it unsafe for them to drive. It puts other road users, pedestrians and the like at risk. In that case, you should explain to the patient what you're planning to do, explain to them that you're going to inform the NDLS, and then once you've done that, if that's what you ultimately do, you should then follow that up in writing with the patient to explain what you have done. But it's a stepwise approach. Notify the driver of their responsibility. If they're unwilling to act on that for any reason, then you may need to act. Explain to them the steps that you're going to take and tell them when you've done so, and keep a very careful record of what what you've done, when you've done it, and why you've done it. Other situations where disclosure in the public interest may be relevant is in relation to things like crime and safeguarding. So there may be situations where disclosing information is permitted, but isn't necessarily required by a particular law. I mentioned the Data Protection Act earlier. The 2018 Data Protection Act permits disclosure of information which would normally be confidential under the Act for the prevention, detection, investigation, or prosecution of criminal offences. That means that you can share information which you have, which you would regard as being confidential in other circumstances, with the police for the purposes of detection or prosecution of crime. The important point here is that the Act permits you to do that without being in breach of the Act, but it doesn't oblige you to share that information. That's the key point. Importantly, it doesn't override your ethical obligations of confidentiality. So there's again a balancing exercise. You may need to consider the nature of the information which is being sought, the seriousness of the alleged offence, as well as the option of seeking consent for disclosure. There'll be other circumstances where disclosure without consent and possibly contrary to the patient's wishes might be justified in the wider public interest. Examples might include whether there is a child protection or safeguarding concern, or if a patient acts in a way likely to put others at risk and can't be dissuaded from doing so. In such cases, it's often appropriate to discuss any proposed disclosure with the patient before you make it, unless, again, this would undermine the purpose of the disclosure. And then again, you should often tell the patient afterwards, preferably in writing, what you've done. In all of these cases, you should carefully document your reasons for sharing information or not sharing it, if that's ultimately your decision, and your discussions with the patient. If you do need to share information without consent, you should just share the minimum amount of information necessary and relevant for the intended purpose. And as I say, these are often very finely judged decisions, and the MDU is often happy to assist when you're faced with them, and we frequently get queries of this nature. So again, another scenario, imagine you are a consultant surgeon. You treated the patient for injuries which were reportedly sustained in a fight. The patient subsequently arrested on suspicion of murder and is now in custody. And again, the Gardaí approach you to ask for a statement. Firstly, do you have consent? And secondly, is there an immediate threat to the public? And that's the important question here, because this patient, as we say, is in custody. Currently, they form no threat to the public. They present no threat to the public. The police know where they are. The police are therefore in a position to approach them to seek consent. And there's no reason in this situation not to say to the police, what about consent? You may end up giving the information because consent has been provided. You may be persuaded ultimately that there is a justification in sharing that information without consent, but the onus would be on the police to give you enough information to justify making that decision. A couple of particular scenarios. One is patients who lack mental capacity and therefore aren't in a position to give consent for their information to be shared. If a patient lacks capacity to make an informed decision about their information being shared, then it's generally acceptable that you do share it if it's of overall benefit to the patient, or if it's required by law, or again, if there's a wider public interest in the information being shared. Bear in mind that capacity is both time-specific and decision-specific. A patient who lacks capacity for other decisions may not lack capacity to be involved in the decision about the disclosure of their records in a particular context. Similarly, they may lack capacity for this decision at a particular time, but that may not be a permanent situation, in which case you should consider whether the decision to disclose can be deferred until they regain capacity. If the loss of capacity is permanent, then it may also be sensible to consider what the patient's views were in the past, if these were known when they still did have capacity. The second situation is in relation to disclosure after death. You'll be aware, and it can back up in the Hippocratic Oath and the Declaration of Geneva, that your ethical obligation of confidentiality continues after a patient has died, but it may still be acceptable to share some information about them which may depend on who's asking, what information is being sought, and what that information will be used for. It would be important to consider any wishes the patient expressed before dying, as well as whether sharing the information would be beneficial or distressing for their family. For example, being given relevant information could help the family understand the circumstances of the patient's death, or could assist in managing the patient's estate. This would not usually mean that they're entitled to see the entire medical record, as it's usually enough to only disclose information relevant to the specific need. You disclose information routinely, of course, in terms of death certification for the coroner, and there is specific guidance in terms of access to records relating to deceased persons, which is available, and I've got a picture of the publication there. Sharing information for things like clinical audit, for education, and similar activities is a necessary aspect of providing safe and effective healthcare. Information should be anonymised or coded if it's being used for these purposes, particularly if it's being shared with those not directly involved in the patient's care. If the information can't be anonymised, and if it is to be used for a secondary purpose, then consent should usually be sought and the patient's wishes respected. Again, this is consistent with medical counsel guidance. I said there wasn't a huge amount of case law in Ireland relating to confidentiality in a medical context. There is this case from 2018, and it related to the disclosure of the HIV status of a patient, patient A. Patient A was in a relationship with patient B. There was a certain amount of factual dispute in terms of what sort of relationship that was, in that A denied that they were having sex with B. But there was a concern that B could be at risk because A had HIV. And this was the first time in Ireland that an order had been sought to breach the confidentiality of one patient for the benefit of somebody else. Everybody agreed that this would be an exceptional situation. The expert evidence in the case, and this is what makes it interesting, was that the risk of contracting HIV was extremely low if A was taking antiretrovirals, and that this risk was further reduced by a vast amount, 99.9%, by the use of condoms. The court concluded that if B was having unprotected sex with A, then she would not be an innocent third party in the legal sense, since she knows or should know that unprotected sex carries with it a risk of sexually transmitted infections, including HIV. And therefore, it was determined in this case that the public interest in medical confidentiality superseded the rights of the person to be warned that if she was engaged in unprotected intercourse, she'd be at risk of HIV. So an unusual case, and I think one which, if you were encountering that sort of case again, you would certainly be seeking legal advice, because each case, of course, will be decided on its own merits. So in summary, confidentiality, as I say, is a core part of the doctor-patient relationship. It's a legal obligation as being an ethical one. It's not absolute, and if you are sharing information, then you should keep a very careful record about what you've disclosed, who you've disclosed it to, and why you've disclosed it, because you may be asked to justify disclosures at a later stage. And therefore, you should share only what information you feel to be necessary and relevant. Just a quick reminder that after the webinar, you will be sent a certificate, and a recording of this will be added to our website in the next 5 days or so. As my voice goes, I put this out to the floor for questions, which Mike and Claire hopefully will field.
Ed, thank you very much indeed. That was just a fantastic overview of what is a really complex area. And for the audience, it might be worth explaining that in this short time, we can only really scratch the surface of this topic. But if any of you do have any questions and you are members of the MDU, then do feel free to contact us. But this is your chance to ask us questions as well. And whilst we go through our list, perhaps I could kick off, Ed. I mean, one of the sort of areas that you sort of touched on, and one of the areas that I think has always caused us difficulty as advisors, is the question of minors, children, where there is a question as to whether the child has capacity to agree or not to information being shared with another person. And this might happen, for example, when the parents split. So what would your approach be, sort of Ed and Claire, when you get that kind of question? You're a sort of doctor in sort of clinic, maybe the sort of child, let's say they're sort of 14 years old, normally comes in with mum, but on this occasion, you get a call during the clinic from dad saying, I want to know information. How would you approach that?
Yeah, well, the age of consent, as you probably all know, for medical treatment is 16 for most things in Ireland. There are specific exceptions to that. So things like psychiatric treatment, remains 18. So it also depends very much on the child's capacity. And I think the first thing you would want to do is assess the child's capacity to give their own consent for dad to get information about that. So there's a concept called Gillick competence that the clinicians will very much be familiar with. It originated in English and Welsh law, but it is certainly persuasive in Ireland, in that the Irish courts will have an eye to the same kind of legal test when they're looking at cases about this. So basically the first step there would generally be to ask the child what their thoughts were on this, to try and ascertain if they had the capacity to say, yes, I do want dad to have some information about this, or no, I don't want dad to know this. So I think that's your first point. And I think with any disclosure, your first point is always, can I get the consent of the patient to make this disclosure? And basically after that, everything is easy. So that would be my first bit of advice on that kind of scenario.
Yeah, thank you, Sir Claire. Any additional thoughts, Ed, from sort of you? Because I sort of do know it's something that we do see quite so regularly, don't we?
Yeah, I think the other thing which is always worth taking into consideration is what would be in the child's best interest, or making sure that what you're disclosing to another party at least wouldn't be contrary to the child's best interest. So if you're aware, for example, that there's a good relationship between the parents, if these are parents perhaps who are separated, for example, if they have joint custody, if the child is spending a lot of time with the father, that certainly may help you make a decision to share information, because it's likely to be in the child's interest for their father to be aware of what's going on in terms of their health. The converse situation is if there's a difficult relationship where the father is not entitled to access to the child, if the courts have prevented that, for example, it's unlikely to be appropriate for sensitive information about the child to be shared with the father in that context. Now, again, it's very much on a case-by-case basis, and there will be others potentially who will have information that might help you make your decision.
Thank you very much, Ed. Claire, I think you might have had a question too, did you?
Yep. A couple have come in. The first one came in actually just before Ed dealt with disclosures with deceased patients, but the question is, if relatives ask for medical information about a patient who's died, can we share that with them under the Data Protection Act? So there were a couple of points arising from that question, and I suppose the first is just to be clear, Ed has covered this, is that disclosures of medical information about deceased patient are actually covered by a different act, and that's the Freedom of Information Act. The Data Protection Act and GDPR apply to living data subjects only. So the couple of other considerations as well. I think these type of requests will come in two big main ways, I think. So the first is immediately after the death. If somebody dies suddenly and a relative comes to the doctor and says, what happened? I think in most cases it's reasonable to disclose anything relevant to that request. You may not want to go into their history 20 years ago, but in general terms, it's reasonable to help relatives understand what happened and why, and what you would disclose is what's relevant to that. The other way that this comes up, and Ed has again touched on that in his slides, and that is when you're trying to settle the estate, or there are life insurance claims or legal claims arising from the death, and the Freedom of Information Act sets out what's relevant to disclose and who can make those requests, and they're under three main categories. One of those categories is the spouse or partner or ex-spouse or ex-partner or next of kin of the deceased. So those types of questions come, you know, in all sorts of ways. So if you have any questions about that, please do call us or write in and ask for specific advice. Mike or Ed, have you anything to add to that one?
I was going to actually follow up with another question that really stems from that. I mean, you're absolutely right. It's one of the things that I think can cause a great deal of unease when you get these requests for disclosure of information after death. One of the other ways it can appear is if you get a letter from a solicitor. Now, if you're in hospital practice, that'll probably go to the hospital, and the hospital management and lawyers will sort of deal with that. But is there anything, are there any particular steps or cautions that people should be aware of if it's a letter from a solicitor regarding a deceased patient, do you think? Ed, Claire, or shall I sort of have a go with that?
I suppose the first thing is the solicitor, you will hope, will explain what information they're asking for and why they're asking for it, that it's not just presented as some sort of fishing exercise. I mean, in some cases, it is very much to try and help with the estates. It may well be that they're asking about the capacity that the patient had to make a will, but in other cases, it will be that they're exploring the possibility of a claim arising from the death in terms of a negligence claim or something similar. So I think it's very important to try and clarify in the first instance what the solicitor is intending to do with the information, and also clarifying exactly what information they want, and not just sort of a general blanket disclosure of everything.
Yeah, I think that really summarizes it extremely well, Ed. The sort of concern always is that sometimes lawyers are very, very good at being slightly opaque as to what they're asking for and the reasons behind it. Now, it may well be that they're acting for a party who is maybe disputing the will of the deceased. It may well be that I think you're bringing a claim on behalf of the estate of the deceased. There's all kinds of things. So if you do get one of these letters or you become aware of them and you're working in hospital, my view is the first thing you should do is let the hospital management know, let them see the sort of letter. They will probably have processes that might involve taking advice from the state claims agency to make sure that all the proper procedural steps are sort of followed. So that's just one to be sort of concerned about.
Yeah. Could I just, I can add to that. Just, I think when you get requests for information, you know, for disclosure of medical information about patients, I think we're kind of programmed as doctors to try and be helpful to people, and our general default is, yes, how can I help you with this? I would say don't be afraid to ask for more information. Don't be afraid to say, what exactly do you need this for? Could you get it in any other way other than me having to disclose medical information? Would it be any good in an anonymized format, or, you know, what do you need it for and why, basically, and have a very low threshold for seeking advice, either from the MDU or from your own hospital legal team on that, because disclosures without consent can give rise to complaints, and sometimes it can be hard to think afterwards, why exactly did I give up that information at the time?
Absolutely, absolutely. Can I just go on to a slightly different area, but actually one that is quite so common, and this is the inadvertent breach of confidence, and it's something that we hear of from doctors who contact us. So, for example, you might be in a busy general ward. You might be discussing as a huddle of doctors with nurses and another healthcare staff near the nurse's station, details of a patient's medical history, and within earshot you've got other people milling about, perhaps other relatives, perhaps non-professional members of the hospital staff. And we have seen complaints arise from those kinds of situations too. So it kind of comes back to one of the earlier points that you made, Ed, and Ed also Claire. And I also wonder what you think about these concerns and structural things that should be put in place to make sure that you don't have any inadvertent breaches of confidence, which are very, very easy to subdue.
Yeah, I would say, you know, from our case files, and I think we would all agree, is that almost all, I mean, the majority of breaches of confidentiality are completely inadvertent. You don't go out of your way to have that conversation. You don't realise that the person standing beside you is not involved in the clinical care of that patient and doesn't have the right to know that information. So I think just be very wary, and I think we are better at this maybe than we used to be as doctors, in that we're more aware of patient confidentiality. But even things like you know, discussing medical information with the patient, say you're clerking somebody in during visiting time, you have to be very aware of who is around you and who's party to that information as well. So I think corridor conversations come up all the time, and they're, you know, they're always inadvertent, and I think all you can do is try and be aware of it, and if somebody complains, if the patient was to say, well, why did you say those things in that context, you apologize immediately, put your hands up and say, I'm really sorry, you know, that happened. And I think that sometimes it goes a good way to addressing the concern, but it's always really regrettable, and we always feel awful if we do those things.
Indeed, yeah, no, I also think so. And the Data Protection Act has got quite specific, and GDPR has got quite specific rules, hasn't it, Ed, to sort of say that you have a sort of legal obligation to secure data, and part of that is to think about these things that sort of Claire's talked about.
Yeah.
Very much so. I think you know the breach when it happens is often a human error at the end of a very long process, but what comes behind that are often systems which weren't really put in place properly to try and prevent or mitigate that human error. So yeah, it's always worth thinking about those systems and having those in place to try and prevent the human error from happening.
That's great. I think we might have time for one very quick question more, if that's okay with you both. This question relates again to the police, and I know that's one that brings people out in a slightly cold sweat when the Gardaí come asking for information. So are there any types of situations where you think doctors have got an obligation to volunteer information to the police about a patient of theirs? My view is that those are incredibly rare, but I wonder whether either of you think there are certain circumstances where it might be necessary to do so.
I think there are, and I think that, as Ed has said, there's not a huge amount of case law to back this up, but where we go for this is medical counsel guidance, and what it makes it very clear that although confidentiality is absolutely central to our doctor-patient relationship, there are very limited circumstances in which we can disclose information about a patient even without their consent, and then there are even fewer situations where we are actually obliged to disclose information, and those are generally in the public interest. So the threshold is really high for those disclosures, and they're generally along the lines of serious crimes against the person, where somebody would be placed at risk of death or serious harm if the disclosure wasn't made. And I would say even in those very, you know, stringent circumstances, if it is possible to get the consent of the patient to make the disclosure, we would generally advise that you do so, unless that would actually place somebody at risk or jeopardize a police investigation. So again, if the police ask you for information, don't be afraid to say, have you got the consent of the patient? Can you get the consent of the patient? If not, why not? And if they can convince you that they're, you know, in the middle of an investigation of a serious crime and this is central to that, then in those cases you can make those disclosures. And again, I would say when you do that, you keep it to the absolute minimum necessary to help the guards with their investigation.
Thank you, Claire. And I think we're just about out of time. It just leads me to, first of all, thank all of you, first of all, for persevering despite the IT problems that we had at the start of this broadcast. My apologies that you had to sit through us trying to work out how things should work. Next time, we will hopefully get all that squared away. But thank you particularly to Ed for very kindly putting together that excellent presentation, and from Claire for also providing her expertise in helping me navigate through some really sort of difficult questions there at the end also. I think I'm right in saying that there will be certificates available to those who have attended the presentation and also there will be a recording, which I think we will probably edit down, so you managed to miss out the first bits that sort of didn't work terribly well. For anyone that wants to go back and revisit any of the points that we have talked about today. So once again, thank you all very much indeed for your time in joining us this lunchtime, and we hope to see you again soon at another MDU webinar.
Thank you.
Thanks all. Thank you very much.